Hi, I'm Kellen Bryant. I'm here to talk to y'all about probate and this big mystery behind this word called probate, and what it's like and how to deal with it. So why probate? Clients usually have to go through probate if they go to the bank. The bank says you need letters. What are the letters? Talking about letters of administration in the probate that the judge signs to give you the authority to go in that account. Another instance where probate comes up if you're looking to sell real estate that the deceased had. Go to the title company and say we can't have this property sold unless there's a probate. So it's usually the prompt for having a probate. There's two main types of probate most commonly seen. Or summary, which I'm not really going to go into here. That's a quicker probate that has lower asset requirements, and then there's a formal probate, which I'm going to talk about right now, which is about a 6 to 11th month process. It could take years in some cases if everyone fights and scrutinizes everything the personal representative does, or scrutinizes the will. It could take a lot longer than 6 to 11 months. So what's probate like? It's like a real estate closing, really. You have steps that must be done before everyone gets the inheritance. So for the personal representative, which is who the person in charge is in Florida, it's also known as the executor or executrix in some states. It's like a job to them. They have to run around, do all kinds of stuff, which I'm about to describe. And it does not, for the beneficiaries, it does not allow for instant gratification. You got to complete the steps before the estate is handed out. In some cases, you might have a lot of beneficiaries, and getting them to sign things to make things go by quicker is like herding cats. Trying to get everybody to sign waivers to make things go a little bit smoother, and I'm going to talk a little bit more about that. So if there's a probate that's needed, step one is to get appointed. If there's no will, the majority chooses who's going to be in charge of the estate. If there's a will, then it's testate, and the person nominated in the will can be in charge of the estate. But in testate estate, it's subject to will challenges, which could slow the process down. Once the personal representative is determined, the second step is to do the job of the personal representative. That means determine where all the assets are, determine what the assets are, what the liabilities of the estate are, what the decedent have, deal with income and expenses, and value those assets. The personal representative has to give legal notice to the creditors of the estate, whether known through mailing them directly or unknown through publishing notice in the paper. The next, the personal representative has to deal with and settle debts if there are any, and make sure they maintain real estate, make sure those taxes are paid, and make sure the mortgage is paid if there is one. Also, the personal representative would deal with who gets what from the estate and deal with any kind of taxes that need to be paid. After the personal representative has done his job and paid all the estate expenses, paid all the creditors, or if there is any, or deal with all the creditor claims, pay all the taxes if there's any owed, and then last, distributing the estate. The personal representative needs to go to the judge and let the judge know that he's done, and the court's going to review all that the personal representative did do, and make sure it's kosher to law. Now, probate can go the easy way or the hard way on this formal probate. The easy way is during all these steps, the personal representative is diligent, beneficiaries sign everything, get it back, and it's easier on everybody and cheaper on the estate. Hard probate, it occurs when people are slow getting back waivers or want a challenge. It makes things go last a lot longer. It's more expensive for everyone involved. So the next steps, if somebody's passed away, usually some family member steps up and they need to gather the will, the trust, get a handle on what assets and liabilities are there, gather a death certificate, and get names of everybody. And after that, you go visit an attorney and then take care of the steps I talked about. Thanks for watching my video.